Rousseau's theory of the general will. Jean-Jacques Rousseau, a leading figure of the 18th century French Enlightenment, appears at first sight as a direct opposite to Hobbes, criticizing private property where Hobbes had naturalized private property, subordinating the state to the people where Hobbes had subordinated the people to the state, standing for freedom where Hobbes had stood for authority. This is very much the image found, for example, in the essays on Rousseau written by the contemporary Marxist commentator Lucio Coletti. He painted Rousseau as an early critic of civil society and the state and argued that Rousseau, quote, sketched the first and basic chapters of a critique of modern bourgeois society, end quote, exposing the ills which flow from private property, prefiguring Marx and Lenin's doctrine of the, quote, withering away of the state, end quote, and anticipating Marx's critique of the, quote, double life of modern society split between, on the one hand, bourgeois individuals intent on securing their self-interest, and on the other, the communal citizens of the state. I believe this interpretation of Rousseau to be largely wrong. The strengths and limitations of Rousseau's eminently bourgeois understanding of society were shared in common with Hobbes and other proponents of classical jurisprudence, what distinguished them being subordinate to what held them together. They shared a common commitment to private property, Rousseau's critique of civil society being confined within the limits of classical jurisprudence. Even as Rousseau attacks the, quote, horrors and misfortunes, end quote, the, quote, crimes, wars, and murders, end quote, which humankind would have been saved from had someone pulled up the stakes or filled up the ditches which mark the boundaries of private property. At the same time, Rousseau was neither able nor willing to envisage an alternative to private property. His work was not aimed at abolishing, but rather at securing its existence and abolishing only its negative side through the establishment of a bourgeois legal order and bourgeois state. The critical edge of Rousseau's indictment of private property still rings true today. Its curse, he argued, the critical edge of Rousseau's indictment of private property still rings true today. Private property's curse, Rousseau argued, lies primarily in the fact that, quote, the loss of one man almost always constitutes the prosperity of another, end quote, and even more perniciously, in that, quote, public calamities are the objects of the hopes and expectations of innumerable individuals, end quote. Property owners, Rousseau continued, are forced to conceal their endless pursuit of self-interest under the, quote, superficial appearance of benevolence, end quote, the better to gain at another's expense. Quote, men are forced to caress and destroy one another at the same time. Men are born enemies by duty and knave by interest, end quote. Massive inequalities grow between the rich and the poor and give rise to a brutal social conflict. Quote, usurpations by the rich, robbery by the poor, and the unbridled passions of both suppressed the cries of natural compassion and the still feeble voice of justice and filled men with avarice, ambition, and vice. End quote. Rousseau. Rather than dissolve into a Hobbesian war of all against all, the rich consolidate their private advantages by claiming for themselves the legitimacy of law and the protection of government. Beneath an aura of public concern and under the shield of the civil magistrate, private interests feather their own nest all the more efficiently. In this defense of wealth and inequality, Rousseau argued, lay the origins of law and the state, which, quote, bound new fetters on the poor and gave new powers to the rich, which irretrievably destroyed natural liberty, eternally fixed the law of property and inequality, converted clever usurpation into unalterable rights, and for the advantage of a few ambitious individuals, subjected all mankind to perpetual labor, slavery, and wretchedness. End quote. Rousseau. Such was the tenor of Rousseau's penetrating critique of civil society, which went much deeper than Hobbes. At the same time, however, it appeared to Rousseau that private property is the inescapable basis of society. Rousseau was critical of Hobbes for seeing private property as the natural form in which human beings appropriate the world around them. The real object of Hobbes' analysis was not, quote, the state of nature, end quote, but, quote, civil society, end quote. Rousseau correctly treated private property as a social phenomenon, but Rousseau could not conceive of any developed social order that was not based upon private property. In the sense that private property appeared as an eternal requirement of all society, private property appeared as, quote, natural to Rousseau, as private property had appeared natural to Hobbes before Rousseau. It was only, Rousseau argued, through the institution of private property that the development of civilization, language, the division of labor, wealth, and the, quote, finer feelings, end quote, of humanity, love, and justice became possible. Thus, Rousseau offered a dialectical view of private property in the sense that it gives rise to the, quote, best and worst, both our virtues and our vices, our science and our errors, our conquerors and our philosophers, end quote. Nothing was further from his mind than private property's abolition. Quote, what must be done? Must societies be totally abolished? Must quote, meum and tuum, mine and thine, i.e. property, be annihilated, and must we return again to the forest to live among bears? This is a deduction in the manner of my adversaries, end quote. The task, as Rousseau saw it, was not to do away with private property, but to construct a form of authority which would do away with private property's contradictions. The difficulty Rousseau faced was to discover how an authority could emerge out of the conditions of civil society, which would genuinely express the, quote, general will, end quote. The unending quest for private gain makes members of civil society more concerned with their own good than that of the public as a whole. While consciousness of the general will exists in each individual, yet when civil society encourages pure egoism, quote, where is the man, end quote, Rousseau asks, quote, who can thus separate himself from himself, end quote, and subordinate his personal interest to the general will. As for the rich, we have already seen that they are interested only in a state which will serve as a veil and instrument of their own special interests. The mass of the poor appear to Rousseau too uneducated to be relied upon to perform public functions. Quote, the laws of kindness, the social virtues of pure minds, all these will never be understood by the multitude. The multitude will always be given gods as stupid as itself, will make slight material sacrifices to those gods, and then honor those gods by giving itself over to 1,000 horrible and destructive passions, end quote, Rousseau. Rousseau's solution to the establishment of an authority which would express the, quote, general will, end quote, of the people was to divorce it radically as possible from the, quote, particular will, end quote, of private individuals and groups. What was the, quote, general will? Rousseau was clear that the general will could not be equated with the empirical, quote, will of all, end quote. While the general will by definition abstracts from the particular will of actual persons and is, quote, always upright and always tends to the public advantage, end quote, by contrast, quote, the actual deliberations of the people do not always have the same rectitude, end quote. The general will is constituted by the general, that is, rational aspects of the will of each individual. So to obey the general will is tantamount to obeying one's own rational general self. Quote, so long as the subjects have to submit only to the conventions of this sort, they obey no one but their own will, end quote. The general will is an authority, quote, formed wholly of the individuals who compose it, end quote, and thus, quote, neither has nor can have any interest contrary to theirs, end quote. The conflict between the particular will of individuals and the general will appears to Rousseau as one between one's will, quote, as a man, end quote, and one's will, quote, as a citizen, end quote. Quote, Whoever refuses to obey the general will shall be compelled to do so by the whole body. This means nothing less than he will be forced to be free, for this is the condition which secures him against all personal dependence." End quote. The foundation of the old order was personal dependence, which was manifest both in the suppression of private property rights and in the private appropriation of the state. The establishment of the general will was to break from all the old oppressions. Gierke, and following on from him, Coletti, have contrasted Rousseau's solution to the problem of civil society and the state to that of Hobbes. They argued that Hobbes and Rousseau both broke radically from natural law doctrines and both rejected the idea of two contracts. Hobbes eliminated the pactum societatis and thus subordinated the people entirely to the state. Rousseau eliminated the pactum subjectionis. Thus, writes Coletti, quote, "attributing sovereignty wholly and exclusively to the people and transforming the institution of government, which was originally a pact between the people and the sovereign, into a mere commission." End quote. Coletti. But neither in form nor in content is this distinction as sharp as Coletti wishes to portray it. In form, the difference between them is that for Hobbes the rational self-interest of the individual is that which accords with the will of the state, while for Rousseau the state is that which accords with the rational will of the individual. While this distinction is important, it should not be forgotten that in both cases the people appear not in their real flesh and blood, but only in formal dress as bearers of reason or general will. Both writers identified the state with the people as a whole, but then turned the quote, people, end quote, into ghosts of their true selves. Gierke argued that for Rousseau, quote, "the destruction of the contract of rulership declared the way for the destruction of every right of the ruler, from the permanent and absolute omnipotence of the assemblage of the people, suspending the executive power and the whole jurisdiction of government. As soon as it assembled, he developed his program of permanent revolution." End quote. Gierke. Gierke's liberalism was horrified at this prospect. Coletti embraces the analysis and gives it the positive connotation which was so alien to Gierke. The theory of the social contract, argues Coletti, quote, "literally constitutes the need for the abolition or, quote, withering away of the state," end quote, end quote. So far as political theory is concerned, I misread that. The theory of the social contract, argues Coletti, quote, "literally constitutes the need for the abolition or withering away of the state, so far as political theory is concerned," end quote. Coletti goes on, quote, "Marx and Lenin have added nothing to Rousseau," end quote. All that bemuses Coletti is why Marx failed to recognize the obvious debt which he owed to Rousseau. The real difference between Hobbes and Rousseau, however, was not one between absolutism and revolution, but rather between one kind of liberalism and another. For Hobbes to presuppose consent to the state, it was sufficient that a rule of law be established to restrict the existing monarchical government. For Rousseau, it was also necessary that the monarchical form of government itself be turned into a parliamentary form of government. While Hobbes offered a theory of the, quote, "legal state" that expressed a compromise between the old monarchy and the bourgeoisie, Rousseau expressed a theory of parliamentary government based on the destruction of the old monarchy. The one represented the English path to bourgeois rule, the other the more radical French path. The rule of law for Rousseau, as for Hobbes, was the key to the constitution of the general will. He waxed lyrical The rule of law for Rousseau, as for Hobbes, was the key to the constitution of the general will. Rousseau waxed lyrical on the wonders of legality. How can it be, he asked, quote, that all should obey, yet nobody take upon him to command, and that all should serve, and yet have no masters? These wonders are the work of law. It is to law alone that men owe justice and liberty. It is this salutary organ of the will of all which establishes in civil right the natural equality between men. The first of all laws is to respect the laws. End quote. Rousseau. For the rule of law to hold good, the innocent must never be punished, specific privileges must never be conferred on any one by name, rules must apply to all equally, justice must never be sold for private gain, the discretionary power of government to absolve people from the effects of law or to pardon them from their offenses must be limited. The law must, quote, provide for the security of the least of its members with as much care as for all the rest, end quote. And it must ensure that it protects the poor against the, quote, tyranny of the rich, end quote. Most important of all, the law must protect private property, for, quote, the right of property is the most sacred of all rights of citizenship, and even more important in some respects than liberty itself, end quote. Private property is the, quote, true foundation of civil society, end quote, and the function of law is not to abolish civil society, but to, quote, guarantee civil society, end quote. What we find in Rousseau is not a revolutionary critique of the bourgeois character of the rule of law as we do in Marx and Lenin, but a liberal critique of an old order where privilege and personal discretion have not yet been supplanted by equality and freedom before the law. The defense of private property was at the very heart of this new conception. Just as private property appeared to Rousseau as the natural form of social production, so too the law appeared as the natural form of social regulation. It was the substitution of, quote, justice for instinct, end quote, which seemed to Rousseau to mark the passage from, quote, a stupid and unimaginative animal, end quote, to a, quote, intelligent being and a man, end quote. The duty of government, Rousseau argued, is above all to guarantee the law. To this end, it must administer it in such a way that it, quote, is impossible for anyone to set himself above the law, end quote. It must teach its citizens to love and respect the laws. Quote, make men, end quote, he says, quote, if you would, command men. If you would have them obedient to the laws, make them love the laws, end quote. Most important of all, the government itself must not abuse the law. It is the mark of, quote, despotism when the rules which purportedly, quote, subject equally the powerful and the weak to the observance of reciprocal obligations, end quote, are subverted and used instead by the rich and powerful to put new fetters on the poor. This does not mean, Rousseau adds, that the government, quote, ought to be afraid to make use of the government's power, end quote, but that the government, quote, the government ought to make use of its power only in a lawful manner, end quote, except, that is, in a state of emergency, when the government has the right to, quote, silence all laws, end quote. Since, quote, it is the people's first intention that the state shall not perish, end quote. Such exclusion clauses, introduced with one eye cocked against the latent threat from the, quote, mob, end quote, below, were characteristic of the most radical defenses of bourgeois legality. Rousseau parted radically from Hobbes in his stress on the relationship which should hold between the legislature and the executive. Coletti, however, misreads this passage, which in fact preached the liberal doctrine of subordination of the executive to the legislature, as a doctrine espousing the dissolution of the state in general. Between these two branches of the state, Rousseau argued, there must be a division of functions, for if the same body of individuals executed the laws as made them, the laws would become, quote, ministers of their passions, and their private aims would inevitably mar the sanctity of their work, end quote. Rousseau argued that the executive must be strictly subordinate to Parliament, that there can be no, quote, contract, end quote, between the executive and Parliament, i.e., no compromise between the old order and the new. For a compromise between the old order and the new would imply the legitimacy of executive power, autonomous of the laws of Parliament. Rousseau himself clarified the verbal difficulties which were nonetheless to confound Guercke and Coletti. Quote, I call the government or supreme administration the legitimate exercise of executive power, and prince or magistrate the man or body entrusted with that administration. The government, i.e., the administration, gets from the sovereign, i.e., the Parliament, the orders it gives to the people. The body of magistrates is simply and solely a commission, an employment in which the rulers, mere officials of the sovereign, exercise in their own name the power of which it makes them despotaries. This power it can modify or recover at pleasure, for the alienation of such a right is incompatible with the nature of the social body. End quote. This subordination of the executive to the legislature has nothing whatsoever to do with the withering away of the state. In fact, Rousseau argued that state officials must be given special powers and privileges distinct from the general population. The, quote, government, or executive, Rousseau declared, must have a, quote, true existence and real life, distinguishing it from the body of the state, end quote. The government or executive must possess its own, quote, particular personality, end quote, as a corporate entity, and this implies, quote, power of deliberation and decision, rights, titles, and privileges belonging exclusively to the prince, and making the office of magistrate more honorable in proportion as the office of magistrate is more troublesome, end quote. The will of Parliament was to constitute the limit of these special powers. The, quote, prince or executive has no right to, quote, usurp the sovereign power, end quote, of Parliament, and Parliament has the right to dissolve and replace the existing executive, since the depositaries of the executive power are not the people's masters, but the people's officers, end quote. Though Rousseau warns that this power should be used sparingly and only as a last resort, the impartiality of the legislative power, Rousseau argued, quote, belongs to the people and belongs to the people alone, end quote. The people, quote, being subject to the laws ought to be their author, end quote. But the question which Rousseau posed was how, quote, a blind multitude which does not know what it wills, because it rarely knows what is good for itself, end quote, can, quote, carry out for itself so great and difficult an enterprise as legislation, end quote. Rousseau's solution, as we have seen, was a constitution based on the supremacy of Parliament. There must, Rousseau says, be, quote, no fundamental law that cannot be revoked, end quote, by the legislature. As long as it has been lawfully and properly convoked, the legislature can enact or repeal what it will. Majority votes must always be binding on everyone, including those who vote against. For, quote, the citizen gives his consent to all the laws, including those laws which are passed in spite of his opposition, and even those laws which punish him when he dares to break any of those laws. When the opinion which is contrary to mine prevails, this proves neither more nor less than that I was mistaken, and that what I thought to be the general will was not so. End quote. Coletti also misread Rousseau's critique of representative democracy. It was based not, as Coletti argued, on a preemptive Marxist critique of the limits of parliamentary representation, but rather on the classical model of the city-state. Rousseau thought that the legislature must be an assembly of the whole people. Quote, sovereignty does not admit of representation. Quote, sovereignty does not admit of representation. Deputies of the people are not and cannot be its representatives. They are merely its stewards, and can carry through no definitive acts. Every law the people has not ratified in person is null and void, is in fact no law. End quote. Parliament, Rousseau was saying in some of his least auspicious passages, must comprise the whole citizenry. Rousseau threw an aside against the populace of England, which, quote, regards itself as free but is grossly mistaken. The populace of England is free only during the election of members of Parliament. As soon as the members of Parliament are elected, slavery takes over the people of England. End quote. Does this classical model mean, Rousseau asks, that, quote, the whole nation must be assembled together at every unforeseen event? End quote. No, he replied to his own question. There is no guarantee that if it were assembled, quote, its decision would be the expression of the general will, end quote. And besides, it would be, quote, impracticable, end quote. The best solution, Rousseau argued at one point in his discourse on political economy, is, quote, where the government is well-intentioned, end quote, to leave it to them to act in accordance with the general will. Rousseau was also well aware that his Greek precedent rested on the enslavement of the mass of the population, and that slavery, by freeing citizens from labor, made possible their direct involvement in political affairs. Is liberty, Rousseau asks, quote, maintained only by the help of slavery? It may be so. Extremes meet, end quote. But this conclusion was irrelevant for a bourgeoisie which produced on the basis of the exploitation of free labor. Rousseau's dictum also meant that a state had to be tiny enough to permit an assembly of the whole populace. His passages extolling the virtues of smallness were largely irrelevant for a revolutionary bourgeoisie eager to subordinate local principalities and pockets of privilege into new nation-states. They reached the point of absurdity when Rousseau outlined his image of a people fit to be given laws, quote, one that has neither custom nor superstition deeply ingrained, one in which every member may be known by every other, one which can do without other peoples. There is still in Europe one country capable of being given law, Corsica, end quote. In these passages, Rousseau expressed the desire of the people as a whole to be involved in politics, but the naive and sometimes regressive form in which he expressed it revealed the shortcomings of even the most radical examples of classical jurisprudence. What he had to offer was not, quote, a radical critique prefigurative of Marxism of the representative state or parliamentary government in the name of, quote, direct democracy, end quote, as Coletti put it, but a parliamentary republic based on the rule of law that nonetheless fell short of the principles of representative democracy that Democrats and Marxists were both later to adopt. Rousseau's backwardness from this standpoint was most marked in his exceedingly conservative view of the natural subordination of women to men, and in his none too flattering image of the actual consciousness of the masses, whose, quote, stupidity, end quote, we have already cited. Rousseau presented his republic as the solution to the contradictions of civil society. Rousseau's own unhappiness with his conclusions can be gauged from his treatment of inequality. Rousseau recognized that civil society breeds huge inequalities between the rich and poor. He wanted the state to ameliorate these inequalities and at the same time not to encroach upon the rights of private property without the consent of private property's owners. It should be remembered that the foundation of the social compact, quote, it should be remembered, quote, Quote, "It should be remembered that the foundation of the social compact is property, and its first condition is that everyone should be maintained in the peaceful possession of what belongs to him." End quote. Rousseau's solution was progressive taxation based on the consent of the taxed. Rousseau justified progressive taxation on the ground that the state, quote, "provides a powerful protection for the immense possessions of the rich," end quote, and, quote, "hardly leaves the poor man in quiet possession of the cottage he builds with his own hands," end quote. Since all the advantages are for the rich should pay a more than proportionate share in the cost of public authority. Rousseau believed that if the rich thought rationally about their situation, they would agree to be taxed up to the point where their wealth was directly attacked. Rousseau's moderation was locked in contradiction. On the one hand, he declared that, quote, "the right which each individual has to his own estate is always subordinate to the rights which the community has over all," end quote. On the other hand, Rousseau assured property owners that, quote, "in taking over the goods of individuals, the community, so far from despoiling those goods," he assured property owners that, quote, "in taking over the goods of individuals, the community, so far from despoiling them, only assures them legitimate possession, and changes usurpation into a true right and enjoyment of proprietorship," end quote. Unable to resolve the contradiction between defense of private property and the collective good, Rousseau kept both options open. Adam Smith's theory of natural liberty. At first, Adam Smith's theory of property seems to be based on an uncritical defense of self-interest, and his theory of the state to be based on the laissez-faire principle of minimum intervention. Smith is best known for his doctrine of the, quote, "hidden hand," end quote, whereby the mutual pursuit of private interest leads, without conscious planning, to the maximization of the public good. While these themes undoubtedly exist in Smith's writing, they are not the whole story. Smith also offered an account of the antagonisms associated with private property and of the interventions required of the state to resolve those antagonisms that went beyond Hobbes and Rousseau. Smith's approach to private property can be read as a response to the moral critiques of egoism which resulted from Rousseau's classicist prejudices. In opposition to Rousseau, Smith argued that the gain of one person does not have to mean a loss for another person, since mutual advantage can derive from the egotistical pursuit of self-interest through the exchange of commodities. Quote, "The propensity to exchange," end quote, appeared to Smith not as a vice, but simply as a natural human characteristic, quote, "common to all men," end quote, and the, quote, "necessary sequence of reason and speech," end quote. Unlike other animals, human beings are from the beginning social and, quote, "have almost constant occasion for the help of their brethren," end quote. The manner in which they procure this assistance is by appealing not to the benevolence of others, but to others' self-interest. Quote, "He will be more likely to prevail if he can interest their self-love in his favor and show them that it is for their own advantage to do for him what he requires of them." End quote. The exchange of privately owned goods is the medium through which the mutually advantageous transaction takes place, one in which, quote, "you give me that which I want, and you shall have this which you want," end quote. Smith analyzed the mechanisms, which Rousseau was unable to discover, by which a person, quote, "by pursuing his own interest," end quote, can promote the general development of civilization. First, an exchange of use values is advantageous for both the parties involved, since they alienate that for which they have no use and acquire that which they desire. Second, quote, It is the power of exchange that gives occasion to the division of labor, end quote. And it is the division of labor which in its turn makes possible, quote, the greatest improvement in the productive powers of labor, end quote, and thus an increase in the general wealth of the nation. In both these ways, statically and dynamically, egoism can be squared with the good of all. The fundamental law of political economy, that, quote, the uniform, constant, and uninterrupted effort of every man to better his condition, is the principle from which public and national as well as private opulence is originally derived, end quote, appeared to Smith as eternal and immutable. However, while the nature of the economic laws themselves did not alter, this is not true of the political and legal conditions under which these economic laws operate. Political and legal conditions which restrict the rights of individuals to pursue their own private interests also restrict the mutually beneficial gains which flow from this egoistic pursuit. Thus, traditional doctrines of natural law, with their specific inhibitions on private property, appeared to Smith as the theoretical expression of just such a restrictive framework, and he counterposed to them a jurisprudence based on, quote, an obvious and simple system of natural liberty, end quote. The great advantage, as Smith saw it, of what he called his own, quote, natural jurisprudence, end quote, over traditional natural law theory was that natural jurisprudence supported the independence or liberty of individuals and the great accumulation of wealth from which all would benefit, while personal dependency and economic stagnation constituted the essence of natural law's attachment of social obligations to property. Quote, independence, Smith argued, was the creation of commercial society. Feudal landowners had maintained large numbers of retainers who were personally dependent upon their arbitrary power. Smith rightly saw this as a particularly degrading form of bondage in which the retainers relied on the good grace and private expenditures of their masters. The collapse of these feudal arrangements and their replacement by market relations between tenant farmers, merchants, and landlords did away with the personal dependence. Laborers were free to transfer their labor from one master to another, and commercial producers sold their wares to any and all who would buy, and thus became dependent on none in particular. Personal dependency does not only corrupt the soul, it also impedes economic growth. Under slavery or serfdom, workers have no personal stake in the progress of production, where, on the other hand, quote, workers are secure of enjoying the fruits of their industry. They naturally exert their industry to better their condition, end quote. Liberty and economic growth go hand in hand. The apparently, quote, hard side of Smith's opposition to natural law theory and natural law theory's tempering of egoism by social duty comes out in Smith's attack on the, quote, policing of grain prices according to notions of, quote, fair price, end quote, and, quote, natural obligation to the poor, end quote, in times of extremity. In Smith's account of 18th century popular struggles over the price of grain and bread, Edward Thompson treats Smith as the arch representative of the harsh spirit of modern commerce, which elevates private gain over the older, quote, moral economy, end quote, of the crowd. But as Holt and Ignatieff have recently pointed out, Smith did not offer this defense of a free market in grain as a dogma for its own sake, but rather argued that a free market would optimize distribution and production. Smith's case for dismantling the assize of bread was based on his claim that the assize kept the price of bread above its natural market price, and he opposed export bounties for the same reason. The progressive aspect of Smith's opposition to natural law was manifest in his attack on the, quote, exclusive privileges, end quote, which monopolies had won for themselves in mercantilist society. He took a firm stance on the side of popular struggles in the 1700s in his opposition to the apprenticeship laws, which were, quote, a manifest encroachment upon the liberty both of the workmen and those who might be disposed to employ the workmen, end quote, to the law of settlement, which violated, quote, natural liberty, end quote, in removing, quote, a man who has committed no misdemeanor from the parish where he chooses to reside, end quote, to the excise laws, which, quote, our merchants have extorted from the legislature for the support of their own absurd and depressive monopolies, end quote, on foreign trade. Smith described the smuggler as, quote, a person who, though no doubt highly blamable for violating the laws of his country, is frequently incapable of violating those of natural justice, and would have been in every respect an excellent citizen had not the laws of his country made that a crime which nature never meant to be so. End quote. The laws of, quote, natural justice were clearly not, in Smith's view, the traditional laws of nature, which never enjoined freedom of trade for all, but the new laws of the, quote, natural liberty and political economy. Smith's critique of the long-standing game laws followed a similar pattern. The game laws set punishments not at all proportionate to the crime for taking things which, quote, by the rules of common equity, end quote, should continue, quote, in common, end quote, and which were enacted on account of the, quote, great inclination of the great to screw all they can out of the hands of the poor, end quote. Smith added his 2 pennyworth to a popular opposition to laws which, dating back to the decline of feudalism, reserved the right to hunt game as a special privilege for landowners of a certain size, thus excluding not only the poor but also smallholders and tenant farmers. Smith saw these barbarous laws, which made violation of a capital offense, not only a denial of liberty, but also as an expression of a backward economy in which the unproductive reservation of land for hunting eroded the commercial use for food production. Smith's defense of the advantages of modern, quote, natural liberty, end quote, over traditional law did not imply that the realm of civil society appeared to Smith self-sufficient or harmonious. He recognized numerous, quote, inconveniences and, quote, disadvantages associated with private property. Commercial society splits asunder the moral sentiments, divorcing personal gain from public duty. While Smith saw egoism as no bad thing in itself, he believed that it must be restrained by respect for the rights of others. Quote, wise and virtuous, end quote, persons should, he argued, be ready to subordinate their private interests to those of the general society. In civil society, the endless quest for material gain, based on the illusory notion that happiness comes from wealth alone, threatens to overwhelm all other moral sentiments, so that neither virtue nor wisdom can be counted on. Smith sought not to condemn egoism, but to marry egoism with public virtue, and it was this marriage which civil society impeded. Smith's crucial discovery was that of the class divisions, inequalities, and antagonisms which accompanied the development of private property. Smith was among the first to recognize the real division of modern society into 3 great orders. Quote, 3 great orders, end quote. Landowners, manufacturers, and laborers. Smith saw these as natural divisions emerging from the very nature of the land, stock, and labor as a form of social organization most conducive to the wealth of the nation as a whole and of all its members, including the poor. Quote, the accommodation of an industrious and frugal peasant exceeds that of many an African king, the absolute master of the lives and liberties of 10,000 naked savages. End quote. At the same time, however, Smith was well aware that the massive inequalities which these class divisions generate cannot be justified by any standards of natural justice. In a, quote, civilized society, end quote, Smith wrote, quote, the poor provide both for themselves and for the enormous luxury of their superiors. The rent which goes to support the vanity of the slothful landlord is all earned by the industry of the peasant. The laborer who bears as it were upon his shoulders the whole fabric of human society seems himself to be pressed down below ground by the weight. In a society of 100,000 families, there will perhaps be 100 who do not labor at all, and who yet, either by violence or by the orderly oppression of law, employ a greater part of the labor of society than any other 10,000 in it. Those who labor most get least, end quote. Adam Smith. Smith entertained no romantic dreams of returning to a society of smallholders where private property is respected but class divisions are absent. Such a state of affairs, Smith recognized, would immediately regenerate the class divisions which he described. His basic concern was rather to analyze how, out of the competition between private interest and the private inequalities which comprise civil society, a public authority could be established capable of resolving these contradictions. The problem Smith posed, which Hobbes and Rousseau had neglected, was to identify a class of persons who could be relied on for the performance of public functions. Smith's problem was that none of the three great classes of modern society could be relied on to perform the duties of government. The particular interest of workers, he argued, coincided with those of society in general, since a rise in wages can occur only if there is, quote, an increase in revenue and stock, end quote. However, laborers were not capable of expressing this social interest because of the corruption of their consciousness. Simple manual labor rendered those whose lives are limited to simple manual labor, quote, as stupid and ignorant as it is possible for a human creature to become. The torpor of his mind renders him not only incapable of relishing or bearing a part in any rational conversation, but of conceiving any generous, noble, or tender sentiment, and consequently of forming any just judgment concerning many even of the ordinary duties of private life. Of the great and extensive interest of his country, the manual laborer is altogether incapable of judging, end quote. The landowning class also had an identity of interest with those of society in general, since, quote, every improvement in the circumstances of society tends either directly or indirectly to raise the real level of rent of land, end quote, and so increase their own wealth. Their consciousness of their own interest was, however, as, quote, defective, end quote, as that of the workers. Quote, the indolence which is the natural effect of the ease and security of their situation renders them too often not only ignorant, but incapable of that application of mind which is necessary in order to foresee and understand the consequences of any public regulation, end quote. This leaves the owners of stock, the manufacturers and merchants. While they, quote, frequently have more acuteness of understanding than the greater part of country gentlemen, end quote, the objective interests of this class are too often at variance with those of the public. Smith argued that economic development tends to lead to a fall in the rate of profit. While they, quote, frequently have more acuteness of understanding than the greater part of country gentlemen, end quote, the objective interests of the manufacturers and merchants are too often at variance with those of the public. Smith argued that economic development tends to lead to a fall in the rate of profit. Conversely, a rise in profit is associated with monopoly and restriction on general development. As a result, the merchants and manufacturers, quote, generally have an interest to deceive or even to oppress the public, end quote, and, quote, neither are nor ought to be rulers of mankind, end quote. When private property subordinates public concern to private interest and creates three classes, none of which is capable of serving the public interest, how can a, quote, natural, end quote, harmony be established between the equally moral sentiments of egoism and public virtue? This was the question which led Smith to address the theory of law in the state. Most critics of Smith's theory of law in the state have focused on his advocacy of laissez-faire as a proper basis for state policy. Taking Smith to be an uncritical advocate for the wonders of the, quote, hidden hand, this interpretation emphasizes his polemic against state intervention in the economy. From this perspective, Smith seems to locate freedom and progress basically in freedom from the state. Smith's theory of the state appears to be a theory of limits on state activity. This theme certainly exists in Smith's writings and informs those passages where he argued, for instance, that, quote, all systems of preference or of restraint being thus taken away, the obvious and simple system of natural liberty establishes itself of its own accord. Every man, as long as he does not violate the laws of justice, is left perfectly free to pursue his own interest in his own way and to bring both his industry and capital into competition with those of any other man or order of men. End quote. But this image offers a one-sided view of what Smith's theory of the state was actually about. The context in which Smith made his anti-interventionist remarks is one of an extended and urgent critique of mercantilism. In this particular instance, Smith had directed his fire against state policies which impede the flow of capital and labor from one area of production to another, from agriculture to manufacture and vice versa. Smith's objection to all preferences and constraints is specifically directed against government interventions which impede the growth of productivity and free trade by establishing artificial privileges and monopolies for favored companies and individuals. Smith does not necessarily exclude other forms of state intervention. Indeed, Smith immediately follows this critique of state intervention by detailing the forms of intervention which are required of the state. Defense, the administration of justice, end quote, the duty of erecting and maintaining certain public works and certain public institutions which it can never be for the interest of any individual or small number of individuals to erect and maintain, end quote. It is true that Smith tried to limit the intervention of government, but this must be taken in the context of his critique of mercantilist interventions. Smith also argued that in any society where there are massive inequalities of wealth, and such inequalities he saw as endemic in commercial society, the establishment of a state power to protect property is an absolute requirement. Commercial society is far too brittle to survive of commercial society's own accord. Quote, it is only under the shelter of the civil magistrate that the owner of that valuable property, which is acquired by the labor of many years or perhaps of many successive generations, can sleep a single night in security, end quote. The view that Smith's theory of, quote, natural liberty was simply a theory aimed at imposing limits on the state ignores his extended critique of the, quote, inconveniences of commercial society and the importance of law and the state for their resolution. In outlining the functions of the state, what was important for Smith was that there are some functions which the state must perform and which must not be left in the hands of private individuals or groups. Thus the problem, as he saw it, with the administration of justice under the old order was that it rested in the hands of bodies which subordinated justice to their own private interests. Were, quote, fees of court, end quote, where, quote, fees of court, end quote, constituted for the nobility a large proportion of their income, there was no hope for remedy. In 18th century Britain, the administration of justice was still tied to private wealth and power. Commercial society, by contrast, made it possible for justice to be separated from private interest and to become the duty of a strictly public authority. The same theme ran through Smith's discussion of the military. Smith affirmed the need and right of every nation to defend itself, all the more so in commercial society, since, quote, an industrious and wealthy nation is of all nations the most likely to be attacked, end quote. At the same time, however, the, quote, natural habits of the people in commercial society render them altogether incapable of defending themselves, end quote. The only solution is for the state to intervene. In all traditional societies, war could be and was left largely in the hands of private bodies. Soldiers supported themselves through their own private means. The expense of arms was relatively small. There was time and motivation for the citizens to practice military skills. In commercial society, by contrast, quote, military exercises come to be neglected, end quote. The citizens no longer possess the time, the money, or the inclination to train themselves or to take the field in battle. The expense of an army and navy had become enormous. The state had to step in. to fund and organize primarily a standing army and secondarily a citizens' militia, with safeguards to ensure that it did not become a danger to liberty. Where military functions continued to be borne by private institutions like the chartered monopolies, they were performed badly and abused. To their own narrow interest of buying cheap and selling dear, they subordinated the defense of the nation. Far from wishing to limit the state's military role, Smith wished to extend the state's military role, to remove the armed forces like the administration of justice from the hands of private individuals and groups, and to relocate them as the exclusive preserve of the state. Smith's espousal of state intervention in education provides a further case in point, but also shows the limits of his interventionism. Quote, ought the public, end quote, Smith asks, quote, to give no attention to the education of the people, end quote. Whereas in the past the function of education could be left almost entirely in private hands, this was no longer the case. Quote, in every improved and civilized country, end quote, Smith argued, quote, some attention of government is necessary in order to prevent the almost entire corruption and degeneracy of the great body of the people, end quote. Quote, the common people have little time for education. The common people's parents can scarce afford to maintain them even in infancy. As soon as they are able to work, they must apply to some trade by which they can earn their subsistence, end quote. In these circumstances, in which the poor are in any case demoralized by their conditions of work, the government must intervene to provide them with a basic education. The state owes this to the poor for the sake of their own intellectual development, since, quote, a man without the proper use of the intellectual faculties of a man is mutilated and deformed, end quote, and it owes it to itself, since, quote, an instructed and intelligent people are always more decent and orderly than an ignorant and stupid people, end quote. In a nation, Smith argues, where, quote, the safety of government rests very much on the favorable judgment which the people may form of its conduct, end quote, the education of the public by the state becomes a top priority. We can see, then, that Smith's theory of the state was not merely a theory of limits on the state. Indeed, his analysis of feudal society points critically to the weakness of the feudal state in relation to the lords, and his analysis of feudal law applauds the first tentative attempts of the state to impose discipline on these lords. The idea of, quote, order and good government, end quote, meant for Smith the legal defense of property, threatened on the one side by the translation of economic into political power by feudal magnates, merchants, and foreign powers, and on the other by the ignorant mob who fall prey to demagogues. The strength of Smith's work as a whole was that he did not simply look to the effect of state intervention on commerce, but also reversed the question to examine the determination of the state and its laws by commercial society. Quote, commerce and manufacture gradually introduce order and good government, and with them the liberty and security of individuals. Quote, commerce and manufacture gradually introduced order and good government, and with order and good government the liberty and security of individuals. This, though it has been the least observed, is by far the most important of all their effects. Commerce and manufacture's effects, end quote. Rejecting entirely the myth of a social contract, Smith offered a detailed historical account of the relations between different, quote, modes of subsistence, end quote, and the forms of law and state to which they gave rise. Quote, property and government, end quote, he declared, quote, very much depend on one another. Quote, property and government, end quote, Smith declared, quote, very much depend on one another, end quote. Smith's account was evolutionary, tracing the development of society and its division of labor through hunting, pasturage, agriculture, and finally commerce. Thus, in a society of hunters, there is little or no property and consequently, quote, no regular form of government, end quote. In pastoral societies, the growth of inequalities between the rich and the poor, quote, requires the establishment of civil government, end quote, to protect property. But government in this period is the exclusive preserve of the landowners, end quote, is in reality instituted for the defense of the rich against the poor, end quote. The sovereign exercised judicial authority as a source of private revenue and without the possibility of any redress against corrupt decisions. Agricultural societies took various distinct forms: allodial, feudal, and absolutist. The laws and government reflected the personal dependence to which the lords, princes, and sovereigns subjected their vast numbers of servants and retainers. Government was simply an extension of these relations of dependence without the presence of any clear distinction between the private rights of the lords and their public duties. Thus, quote, not only the highest jurisdiction, both civil and criminal, but the power of levying troops, of coining money, and even that of making bylaws for the government of their own people, were all rights possessed allodially by the great proprietors of land, end quote. Smith. The emergence of absolutism did not fundamentally alter this situation of personal authority and dependence. The emergence of absolutism simply concentrated authority among a few of the most powerful lords and monarchs. The class inequalities regenerated in commercial society made the persistence of law and government imperative, but, and this was the nub of Smith's lengthy argument, law and government could be dissociated from privilege and dependence. It was the independence of the laborer, the tenant farmer, the tradesman, and the artificer from reliance on a particular lord, so that they are, quote, obliged to all, end quote, but not, quote, absolutely dependent upon anyone, end quote, which provided the foundation for a political, quote, system of liberty, end quote. The great advance from which Smith made in constructing a historical account of law and the state has been celebrated by Ronald Meek as a direct forerunner of Marx's materialist approach. We should, however, note that it was vitiated by an evolutionary framework which posited history as a succession of phases, culminating in the mature and final phase of commerce as the, quote, natural condition of society. Smith also faced a methodological difficulty in relating jurisprudence to economics, which he never solved. Since he considered the, quote, propensity to exchange, end quote, to be a natural and eternal fact of human life, Smith was able to distinguish different modes of subsistence only by, on the one hand, the technical development of the division of labor. Where it was least developed, there was least opportunity to exchange, and on the other, by its laws and government. In the first case, Smith found himself committed to a technological determinism. In the second, he was trapped in a circular argument, explaining law and the state by a mode of subsistence, which was itself determined by law and the state. The technical determinism of the one was as unsatisfactory as the circularity of the other. Smith never resolved this problem. The major shortcoming of Smith's historical account lay in his equation of commercial society with a society organized according to the laws of nature. His attempt to portray this product of history as the fulfillment of human nature turned his, quote, historical materialism into a, quote, historicism that attributed a natural goal to historical development. Smith was right to reject social contract theory in favor of materialism, but his materialism, rooted in a naturalistic account of human sentiments, was abstract. He no longer based the state on the abstract consent of the people, as expressed in social contract theory, but he identified the state with the equally abstract idea of the natural sentiments of the people. The crucial link, Smith argued, between the egoistic and the social individual is human sympathy for the passions of other people. This appeared to Smith as a natural human trait. Sympathy leads us to assess the, quote, propriety, end quote, of people's conduct on the basis of how others feel about it. Thus, if one person harms another, we feel a, quote, sympathetic resentment, end quote, at the injury done and look to the punishment of the wrongdoer. The particular twist which Smith gave to his theory, which he inherited from Hume, was to abstract the idea of, quote, sympathy from the actual feelings of men and women. First, he meant by sympathy a capacity to share in the passions which other people should feel in a given situation, irrespective of whether or not they actually feel those passions. Quote, sympathy does not arise so much from the view of the passions as from that of the situation which excites passions, or excites sympathy, end quote. One may sympathize with the affliction of an idiot who may be happy or unaware of his or her affliction, or of a dead person who feels no passion at all. We put ourselves in their shoes even if they cannot respond appropriately. Second, Smith meant by sympathy the feeling that someone ought to have watching a particular situation. Smith meant by sympathy the feeling that someone ought to have watching a particular situation, rather than that, the feeling which he or she actually has. Sympathy becomes the attribute not of concrete persons, but of a, quote, well-informed and impartial spectator, end quote. Justice is based on the sympathies felt by this impartial spectator for what ought to be the passions of those who have been injured. People soon discover that they are the objects of evaluation by other people, and begin to judge themselves as others judge them, or rather, as an impartial spectator would judge them. The impartial spectator within us becomes, quote, reason, conscience, principle, the inhabitant of the breast, the man within, the great judge and arbiter of our conduct, end quote. The sense of, quote, propriety, end quote, on which impartial spectators base their assessments is dependent on particular situation. The sense of propriety changes with place and time, but in any given situation there exists a definite judgment which the impartial spectator holds. The problem Smith saw as facing civil society was the divorce between the actual sentiments of real people and the ideal sentiments of impartial observers. The egoism associated with private property, while good in itself, tended to block out sympathy for others. Smith's solution in part reflected Hobbes and Rousseau's formalism. It lay in the establishment of an external authority which would embody and, where necessary, enforce the sentiments of the impartial observer, and which individuals could look as the expression of their own, quote, inner voice. The state was to be based not on the real sentiments of real people, but on the, quote, proper sentiments of ideal spectators. The result was at times a rather arbitrary identification by Smith of those laws and constitutional arrangements which he supported with the impartial spectator's mark of approval, and conversely those he did not support with an imaginary scowl of disapproval. When people fail to have a clear view of justice, in cases where their own interests are involved, where, for instance, quote, every man revenges himself at his own hand whenever he fancied himself injured, end quote, the state must, in Smith's view, intervene lest civil society become, quote, a scene of bloodshed and disorder, end quote. Smith's specific contribution was to address the conditions necessary to bring the actual sentiments of the people nearer the ideal sentiments of the impartial observer. He hoped that society would develop in such a way that the two would become the same, especially if everyone had a sufficiently wide circle of acquaintances in broad education, and that reason would thus prevail without state intervention. At the same time, state intervention, for example, in the form of education and law, was needed to transform these social conditions. While Smith resolved his ambivalence generally in favor of minimum intervention, later writers were to develop programs of far more extensive social economic legislation without violating any of Smith's basic assumptions. Smith's constitutional conclusions were built on the foundations of the liberal state already laid by Hobbes and Rousseau. At the center of his, quote, system of natural liberty, Smith's constitutional conclusions were built on the foundations of the liberal state already laid by Hobbes and Rousseau. At the center of Smith's system of natural liberty was the impartial administration of justice. The rules of law should be general, determinate, apply to all equally, and admit to, quote, no exceptions or modifications, end quote. The biggest threat to the rule of law Smith saw as deriving from, quote, the interest of the government, end quote, as a corporate body, i.e. the state executive, or from, quote, the interest of particular orders of men who tyrannize the government and warp the positive laws of the country from what natural justice would prescribe, end quote. The danger was that the executive would absorb, quote, every other power in the state, end quote, and assume for itself, quote, the management of every branch of revenue which is destined for any public purpose, end quote. To prevent this, the right of imposing taxes was to be reserved for the, quote, assembly of the representatives of the people, end quote. Ministers were to be impeachable. Habeas corpus was to ensure against arbitrary imprisonment. The independence of the judiciary was essential, by which he meant independence not just from private interests, but also from executive power. Quote, in order to make every individual feel himself perfectly secure in the possession of every right which belongs to him, it is not only necessary that the judicial should be separated from the executive power, but that it should be rendered as much as possible independent of the executive power. The judge should not be liable to be removed from office according to the caprice of the executive power. The regular payment of the judge's salary should not depend upon the goodwill or even the good company of that executive power, end quote. Smith was unclear how this independence was to be secured in fact. Should judges be paid salaries or be men of independent means or be paid a market fee in such a way as to block off the possibility of corruption? And Smith played around with a number of possibilities. Smith was, however, clear that judicial independence meant freedom from bureaucratic pressures and not from legislative direction. The right of judges to vet executive decisions, but not to vet Parliament. Smith shared Rousseau's fears about the despotic character of state bureaucracy, but appreciated, on the basis of British experience, that bureaucracy was not a hangover from absolutism, but a new and dangerous principle which threatened liberty as much as did the private interests of merchants. Smith's ideal of the rule of law was intended not as a ratification of state power. Smith's ideal of the rule of law did not convey an unconditional obligation to obey the laws of the state, whatever their form or their content, but rather as an expression of what Edward Thompson has called, quote, a cultural tradition of bloody-mindedness towards the intrusion of authority, end quote. Hegel's theory of the rational state. The political consequence of this principle, of the, quote, infinitely free personality, end quote, is the modern European state whose task it is to reconcile the principle. This is a quote. Quote, the political consequence of this principle, of the, quote, infinitely free personality, end quote, is the modern European state whose task it is to reconcile the principle of the polis, substantive generality, with the principle of Christian religion, subjective individuality. In this dialectical harmonization of two opposing powers, Hegel sees not the peculiar weakness, but rather the strength of modern states. The generality of the polis is of no value without the particular willing and knowing of the individuals, and the individuals are of no value when they do not themselves will the general will of the state. Hegel considered this synthesis not only possible, but actually accomplished in the contemporary Prussian state. End quote. Karl summed up the central problem faced by Hegel: how to reconcile individual freedom with the general will, private property and the state, the principle of, quote, particularity, and that of, quote, universality. The problem is on the one hand philosophical, to create a synthesis between the classical ideal of the polis, the city-state, in which the will of the community as a whole predominates at the expense of subjective freedom, and the bourgeois ideal of individualism, in which the rights of individuals to pursue their own interests predominate at the expense of public authority. It was also a historical problem. Bourgeois society brought with it the rights associated with private property and in their name attacked, and in the case of the French Revolution, demolished those states which no longer corresponded with its idea of freedom. All this was, as far as Hegel was concerned, to the good. All bourgeois society brought with it, but bourgeois society brought with it the danger that subjective freedom would turn into mere egoism and that particularism would overwhelm universalism. It was not enough to demolish the old state. A new state had to be established in its place. The principle of the new state was to fuse the satisfaction of private desires, caprices, interests, and needs with the obedience to an external authority which represented the social whole. Hegel sought a solution in the form of a, quote, rational state, end quote, at once dissociated from the private interests which comprised civil society and premised on their preservation. This involved him in a twofold attack. On the one hand, he opposed feudal critics of the modern state. See, for example, his polemic against von Haller, who based the state on the rule of the strong over the weak and denied any association between the state and individual rights. Such a conception, far from dissociating the state from private interest, turned the state into a private interest, and far from preserving the sphere of private interest, threatened the sphere of private interest at every point. On the other hand, Hegel opposed, quote, subjectivist critics of the modern state. Witness his polemics against Fries and the student radicals, who rejected all external authority in the name of moral subjectivism. Hegel attacked their belief that the only right is what one feels to be right. He argued that such an ethos allows people to do as they will and justify whatever they do on the basis of good intentions. As a result of such a philosophy, quote, all the trouble of rational insight and knowledge is of course saved, end quote. Any crime may be justified by reference to the subjective meaning. Any law may be condemned as a shackle on one's inner feelings. For Hegel, criticism of existing positive laws was to be drawn from the standpoint of, quote, rational law, end quote. The repudiation of all law from the viewpoint of subjective conviction merely elevates the egoism of civil society into an absolute principle at the expense of any external authority. The task, as Hegel saw it, was not to do away with external authority, in which case self-interest and self-conceit are given full rein, but to make external authority rational. In contrast to absolutism and subjectivism, Hegel saw Hobbes, Rousseau, and Smith as having made great advances in the formation of a rational state, but Hegel saw their accomplishments as incomplete. To some extent, Hegel simply translated their concerns into the language of speculative philosophy, in inheriting their identification of private property with freedom and the state with reason. However, he took their ideas ultimately down a quite different path. Private property seemed to Hegel to represent the triumph of, quote, free mind, end quote, over external nature. Hegel argued that the distinguishing mark of human freedom is that humans, unlike animals, are not restricted to natural instincts and fixed ways of satisfying those natural instincts. Rather, through the mediation of labor, humans transform nature to make nature useful to themselves, and in the same process transform their needs and their means of satisfying those needs. Hegel associated humanity with the conquest of nature, not subjection to it, and criticized the romantic identification of freedom with nature, reflected in Rousseau's rhetorical quip that, quote, man was born free but is everywhere in chains, end quote. While labor initiates the process of human transcendence over nature, Hegel saw the institution of private property as giving a form adequate to this process, one in which a person exercises, quote, the right of putting his will into any and everything and thereby making it his, end quote. What is essential in private property is the, quote, will. The natural characteristics of the thing become no more than the accidental form in which people objectify their will. Hegel argued that private property implies recognition by others of oneself as a free human being. When others respect your property by not trespassing on your property, they respect you as a human being. The establishment of private property represents a mutual recognition of people as free and rational beings expressed in the form of the contract, whereby, quote, the parties entering into that contract recognize each other as persons and property owners, end quote, and recognize each other's right to buy and sell as they choose without constraint. Private property expressed for Hegel the subjective freedom of the individual. Owners of private property can do as they wish with their property, use their property, abuse their property, exchange their property, keep their property. It is a matter reserved for their discretion, their caprice, their arbitrary desire. Hegel identified the individual freedom of property owners to do as they please with more general individualistic values like, quote, love, romanticism, the quest for the eternal salvation of the individual, moral convictions, conscience, etc., end quote. The product of self-interest appeared to Hegel as mutual satisfaction, Smith's, quote, hidden hand, end quote, being translated into the dialectic of reason. As with Smith, it is the division of labor and exchange which, quote, makes necessary everywhere the dependence of men on one another and their reciprocal relation in the satisfaction of their other needs, end quote. One person's gain becomes, through the division of labor and exchange, not another's loss, but another's means of self-satisfaction. It is thus that Hegel discovered, quote, in the sphere of needs this show of rationality, end quote. Hegel's critique of Smith was aimed at the merely contingent character of the link he formed between freedom and private property. Smith justified private property as a means of satisfying human desires, but for Hegel, private property was no longer a means of satisfying needs, but, quote, the first embodiment of freedom, and therefore a substantial end in itself, end quote. Private property was presented by Hegel as the essential embodiment of free will and human personality. For Smith, freedom derives empirically from the existence of private property. For Hegel, private property derives logically from the idea of freedom. Subject and predicate are inverted. The march of freedom becomes the subject of history, while private property becomes freedom's predicate at a certain stage of freedom's historical progress. Free will appears as the foundation of private property rather than private property as the basis of free will. Though Hegel made absolute the connections between private property and freedom, Hegel did not abandon classical critiques of the contradictions inherent in civil society. Since civil society is the sphere of, quote, universal egoism, end quote, the pursuit of unrestrained self-interest threatens to pull it apart from within. Quote, by means of its own dialectic, the civil society is driven beyond its own limits as a definite and self-complete society, end quote. The inherent tendency of private property is to turn freedom into license. What results is a spectacle of excess, misery, and physical and social corruption, end quote. Oh, I gotta repeat that. Since civil society is the sphere of, quote, universal egoism, end quote, the pursuit of unrestrained self-interest threatened to pull it apart from within, quote, by means of its own dialectic. The civil society is driven by its own limits as definite and self-complete society, end quote. The inherent tendency of private property is to turn freedom into license. What results is a spectacle of excess, misery, and physical and social corruption. Poverty is the inescapable byproduct of civil society. While Smith may be right that the modern peasant is better off than the old tribal chief, Poverty is relative and should be measured against the new needs generated by society. On the one side of civil society lies the massive accumulation of wealth, on the other, impoverishment. Quote, when the standard of living of a large mass of people falls below a certain level of subsistence, and when there is a subsequent loss of the sense of right and wrong, of honesty and self-respect, the result is the creation of a rabble of paupers. End quote. The contrast between wealth and poverty fills the poor with, quote, inner indignation and hatred, end quote, making the poor incapable of leading a public life or of acting, quote, in the spirit of the whole, end quote. As for the wealthy business class, they sink into their own private concerns, interested only in their own prosperity at the expense of all else. As the wealthy business class become preoccupied with their private affairs, public life becomes an alien power remote from their own interest and left to social forces, the monarch, the estates, who are themselves no more than private interests. They have no regard for the whole. Private property is turned, quote, into an absolute, end quote. The agricultural class, tied to a patriarchal way of life and to the natural products of the soil, have a mode of subsistence that owes little to intelligence or independence of thought. While they are more suited to public affairs by virtue of being free from immediate pressures of the market and of possessing independent means, they are too unreflective, simple, subservient for a public role. Hegel perceived the negative side of Smith's, quote, hidden hand, end quote. The market is, quote, an alien power, end quote, over which the producer has no control. This dependence is illustrated when, quote, whole branches of industry which supported a large class of people suddenly fold up because of a change of fashion or because the values of their product falls due to new inventions in other countries, end quote. The key to the problem of civil society is that a free society should be the conscious subject of its own development. In civil society, the integration of separate private interests into a general line of development is the product not of free rational decisions, but of chance and necessity. The question Hegel faced was whether, out of the particularism that characterizes civil society, it is possible for the principle of universality to arise as a real social force. Hegel's critique of Hobbes, Rousseau, and Smith was directed both at their belief that it is possible and at the specific. Hegel's critique of Hobbes, Rousseau, and Smith was directed both at their belief that it is possible and at the specific solutions which they proposed. In Hegel's view, the contradictions present in the, quote, universal egoism, end quote, of civil society were too irreconcilable for a public spirit to emerge out of that universal egoism. The contradictions of universal egoism. Rather than derive the universal state from the particular interests of civil society, the state had to be established in the state's own right and imposed on civil society. The classical theorists had never fully broken from the perspective of members of civil society, according to which the state appeared as no more than a guarantee of their self-interest, a means for the protection of private property rather than as a self-sufficient principle which transcends private property. It would be difficult, for example, Hegel argued, to justify taxation on the basis of rational self-interest, or even more difficult to justify military service. Each of these is a duty which goes beyond the interest of the citizen as a private person. Civil society is a, quote, system of needs, end quote, in which the individuals see others as no more than means for securing their own private ends. Classical writers reproduce the vantage point of civil society when they treat the state as no more than a means of satisfying egoism. The divorce of the state from civil society, initiated by classical jurisprudence, had to be completed. Because it is ruled by blind market forces, civil society cannot be a sphere of, quote, objective freedom, whereas the state, because it embodies the self-conscious will of the people as a whole, is the sphere of objective freedom. So Hegel concluded, Hobbes was right. Civil society must be subordinated to the state rather than the state being subordinated to civil society. It was this reversal of the relation between civil society and the state that has given rise to the impression of Hegel as an absolutist. Hegel's commitment to the, quote, absolute authority, end quote, of the state has been interpreted as marking a shift in bourgeois thought away from its radical phase when it counterposed natural right to established authority to bourgeois thought's authoritarian maturation when it demanded unconditional obedience to a state now in bourgeois hands. It seemed that Hegel's subordination of individual rights to the collective will weakened the foundation for the protection of civil liberties. It also gives rise to the impression of Hegel as a proto-revolutionary, putting community before property, the general good before private interest, conscious planning before blind market forces. Hegel's ideal state was no longer a servant of private property, but the autonomous embodiment of the will of the community. Neither version, however, captures the real significance of Hegel's reversal of the relation between civil society and the state. On the one hand, as a counter to absolutism, he argued that the rational state must generate a sphere of individual freedom. On the other, as a counter to revolutionism, he argued that the state must guarantee private property. The state, in other words, had to, quote, posit civil society as a, quote, moment in its own formation. Hegel pursued this philosophical revision of the relation between civil society and the state into his analysis of law, welcoming the attack on traditional natural law theory initiated by Hobbes, Rousseau, and Smith. All law, Hegel declared, is positive. That is, posited by human beings. Natural law is the illusory form which law takes before human beings become conscious of their freedom to make laws as they choose. Hegel was scathing in his critique of the, quote, old rights, end quote, enjoined by natural law theory. Quote, all old rights, end quote, are such fine grand words that sounds. Sorry, there's a typo here. Quote, old rights are such fine grand words that it sounds impious to contemplate robbing a people of its rights. But age has nothing to do with what, quote, old rights, end quote, mean or whether those old rights are good or bad. Even the abolition of human sacrifice, slavery, feudal despotism, and countless other infamies was in every case the cancellation of something that was a, quote, old right, end quote. Hegel. Law must represent freedom in its content, and so cannot justify slavery, freedom, or personal dependence, and in its form, and thus cannot take the form of natural law. The idea of, quote, rational law, end quote, Hegel argued, is premised on free will in both form and content, that is, on the freedom to posit law without natural constraint and on the freedom of private property under law. Hegel's correct critique of Hobbes, Rousseau, and Smith was that in one way or another, they all resurrected natural law theory in the form of a natural right to private property. For Hegel, the authority of positive law was to encounter no such, quote, natural, end quote, barriers. The connection between private property and the law was not an external one of protection or preservation, but an immanent connection of form. The idea of a legal subject, that is, of one who possesses rights, implies ownership of private property, or to put the matter in reverse, private property is the external form taken by the concept of, quote, right, end quote. Quote, right is the immediate embodiment which freedom gives itself as an immediate way, i.e., possession which is private ownership, end quote. The connection between law and private property, in other words, is not contingent but essential, not a matter of content but of form. Law should not be analyzed in terms of the protection of private property, but as private property's embodiment. The rationality of law, Hegel argued, lies in law's, quote, universality, end quote. The law treats everyone alike. Each owner of property is equal to every other. No property owner has privileges, and none may be barred from ownership. The right of ownership is implicit in the human personality as such. Everyone is free because at the very least, everyone owns their own, quote, mental endowments, end quote, or capacity to labor. This is the quality of law that previous classical writers idealized. Hegel, by contrast, pointed out that the universality of law was purely, quote, abstract, end quote. What and how much a person owns is, quote, a matter of indifference as far as rights are concerned, end quote. For law is concerned only with the, quote, equality of abstract persons as such, end quote, and not with differences like the amount of property they happen to possess. Thus, short of alienating one's whole personality as in slavery or serfdom by selling the, quote, entire time of one's concrete labor, end quote, the real dependence of one individual on another, manifest in the relation between worker and capitalist, is outside the sphere of right and compatible with legal freedom and equality. From the fact that the universal character of law is only formal, Hegel did not conclude that it was therefore meaningless or illusory, but rather that it was limited. Freedom and equality before the law, Hegel argued, provided a minimum of freedom and equality, and must accordingly not be discarded. However, by themselves they are not sufficient to embody the universal will. Far from rejecting equal right as myth, Hegel sought to translate equal right into a legal system based on definite formal standards. Laws must be universally known, for only the tyrant would, quote, hang laws so high that no citizen could read those laws, end quote. Laws must be general, applying to all equally and referring to none by name. Laws must be determinate in order that their application to particular cases be not arbitrary. Retroactive legislation must be ruled out. Trials must be conducted by a, quote, public authority, end quote, and no longer be, quote, optional acts of grace or favor on the part of monarchs and governments, end quote. Trials must be held in public since the, quote, right at issue affects the interest of everybody, end quote. They must be held before lay juries since, quote, knowledge of the facts of the case involves no pronouncement on points of law, end quote. And juries must comprise the peers of the accused since confidence in them is based, quote, primarily on the similarity between them and the parties in respect to their particularity, i.e. their social position, end quote. Judges should have some discretion in applying universal laws to particular instances, since it is a matter of contingency whether, for example, quote, justice requires for an offense corporal punishment of 40 lashes or 39, end quote. And since the important point for Hegel was the practical requirement that, quote, something be actually done no matter how, end quote, laws should be codified either in statute or in case law, since the, quote, just systematization, end quote, of law is what, quote, our time is pressing for, end quote. Hegel was critical of what he saw, wrongly perhaps, as the principle of English common law, that judges are themselves the, quote, repositories of the unwritten law, end quote, and so became in effect legislators exempt from the authority of their predecessors. Legislation may pertain only to that which is in principle external, quote, external, and not, as was the case in ancient society, to, quote, the field of inner life, end quote, love, feelings, integrity, etc. Right must be determined by formal legal procedures, since in spite of widespread antipathy to legal formalities, they are the means by which the, quote, validity of my will should be recognized by others. Forms of punishment are a matter of contingency related to the conditions of particular societies. Where societies are stable, punishments may be mild. Where societies are weak, punishments may for the same offense be severe in order to set an example. What was important was only that punishments be legal and that no crimes be left unpunished. The rule of law was, in Hegel's terms, the ideal legal system which realized the concept of right and marked the victory of freedom over despotism. Quote, despotism means any state of affairs where law has disappeared and where the particular will as such, whether of a monarch or a mob, counts as law or rather takes the place of law. End quote. The formal character of equal rights means, however, that under the rule of law alone, blind market forces will not be subordinated to conscious direction. Inequalities between the rich and the poor will not be overcome. Relations based on exchange of property will not be replaced by, quote, true association, end quote. And the subjective will of the individual will not be meshed into the rational will of the whole. Even an ideal legal system will not be the final point of integration of civil society, since an ideal legal system's universality pertains only to the abstract rights of private property and not to the needs of real individuals. The solution in Hegel's view was not to get rid of the restricted amount of freedom and equality which the rule of law provided, but to supplement the rule of law with a force capable of governing the, quote, particular, end quote, aspects of people's lives. Following on from Smith and others, Hegel called this the, quote, police, end quote, and defined its role as providing welfare for the poor, a fair balance between the interests of producers and consumers, public health care, public building works, a public education system, and the planning of various aspects of private production. In short, as creating a balance which Hegel never specified between the freedom of trade and the general good. The problem Hegel faced was how to construct a, quote, police without resurrecting the specter of despotism. Since the law was an aspect of civil society, Hegel's solution lay in the formation of a state more radically divorced from civil society than the doctrine of the, quote, legal state, end quote, made possible. The key to the rational state in Hegel's view was that the people themselves should enter government only in their, quote, rational form. Yeah? No. Okay. Their influence on government, in other words, must be mediated in order that it be a rational influence and not merely a reflex of the passions of the, quote, rabble, end quote. Unmediated public opinion comprises no more than a, quote, hodgepodge of truth and endless error, end quote. The point of mediation is to sift the true from the false, the rational from the irrational. Nothing could be worse, in Hegel's view, than for the people to run the state by other than, quote, legal and orderly means, end quote. For if such means are lacking, the, quote, voice of the masses is always for violence, end quote. Hegel shrank from the prospect of the, quote, democratic element, end quote, coming into the, quote, organism of the state without any rational form, end quote. As, for instance, in Rousseau's proposal that, quote, every single person should share in deliberating and deciding on political matters of general concern on the grounds that all individuals are members of the state, that its concerns are their concerns, and that it is their right that what is done should be done with their knowledge and volition, end quote. Rousseau. Hegel saw in this a recipe for disaster. For the rational will of the people to predominate, first the rational part of the population, centered around the middle classes, was to be separated off from the irrational part, women and children at least, quote, women and children at least, end quote, and the latter excluded from participation in the state. Thus Hegel called the people the, quote, many, rather than the, quote, all. Second, a system of mediations had to be established to serve as a kind of filter through which reason might pass and unreason be kept out. Hegel's first mediation was the Constitution itself. In the Constitution, he argued, it is expressed the rational will of all. The Constitution embodies the unity of the state. The three functions of government, executive, legislative, and monarchic, are but the organs of the Constitution working in harmony with one another. For Hegel, prefiguring later developments in legal positivism, it appeared meaningless to ask where a constitution came from, since a people by definition, as opposed to a, quote, formless mass, end quote, must have a constitution. The existence of a constitution is thus turned into a premise rather than a product of organized social life. Quote, "It is absolutely essential that the Constitution should be regarded as something made, even though it has come into being in time. It must be treated rather as something existent in and by itself, as divine therefore and constant, and so as exalted above the sphere of things that are made." End quote. The will of the people had to be constitutional to be rational. This does not rule out innovation, but restricted rational innovation, to which is constitutionally legitimate. Hegel thought that real advances in the Constitution were often, quote, "imperceptible," end quote, "tranquil in appearance," end quote. Over a long period of time, a constitution maintains its own outward appearance, but gradually turns into, quote, "something quite different from what it originally was," end quote. While gradual constitutional change appeared to Hegel, in passages such as these, as the only rational means of reform, there was an ambivalence in his thought resulting from his immediate awareness that the modern Prussian constitution, of which he approved so warmly, had been imposed by Napoleon in a manner that was neither constitutional nor gradual. Hegel's next mediation was the system of representation. The deputy in Parliament was to represent the means by which truth was to be culled from the field of conflicting prejudices that make up public opinion. Quote, "Since deputies are elected to deliberate and decide on public affairs, the point about their election is that it is a choice of individuals on the strength of the confidence felt in them, i.e., a choice of such individuals as have a better understanding of these affairs than their electors have, and such also as essentially vindicate the universal interest, not the particular interest of a society or corporation." End quote. Thus, the relation between electors and their representatives was not to be one of, quote, "agents with a commission or specific instructions," end quote, but a relation of, quote, "trust," end quote, in which representatives were mandated to make their own decisions on the basis of their own greater knowledge and expertise in public affairs, and on the basis of debates within the assembly, since it was there that all the members, quote, "deliberate together and reciprocally instruct and convince each other," end quote. A more archaic mediation was to be secured through the establishment of, quote, "estates." Hegel argued that in civil society, people do not appear as, quote, "a mere indiscriminate multitude," end quote, nor as, quote, "an aggregate dispersed into atoms," end quote. In civil society, people appear rather organized into classes. These classes, Hegel suggested, mirroring a traditional form of argument, should be given political significance as, quote, "estates," end quote. That is, people should vote for their representatives not on the basis of universal suffrage of individuals, but as members of these, quote, "estates," end quote. Where people vote as individuals, it leads to, quote, "electoral indifference," end quote, since a single vote is, quote, "of no significance where there is a multitude of electors," end quote. This in turn leads to concentration of power, in fact, into the, quote, "hands of a few," a caucus, end quote. The decisive reason Hegel puts forward for election to be based on estates is that at no point should the people appear as, quote, "an unorganized aggregate," end quote. For in this case, the people are a, quote, "formless mass whose commotions and activity could only be elementary, irrational, barbarous, and frightful," End quote. This also informs Hegel's analysis of, quote, corporations, end quote, which are meant to organize particular interests within civil society and represent those interests to the state, while remaining themselves, quote, under the surveillance of the public authority, end quote. Hegel had an intense distrust of, quote, unorganized, end quote, masses. Not only, Hegel said, should voting be organized around the representation of estates, but the assembly should be divided into two houses, the upper house of which should be reserved for the landowning estate. Hegel justified this unelected upper house on the grounds that the landowning class were naturally suited to political position, since their fixed ownership of land allowed them independence of the market, the executive, and the, quote, mob, end quote. The great advantage of this arrangement in Hegel's view was that it acts as, quote, a surer guarantee of ripeness of decision, end quote, and that it means that, quote, there is less chance of the estates being in direct opposition to the executive, end quote. Thus, Hegel did not only purport to derive a particular kind of representational form. Thus, Hegel did not only purport to derive a particular kind of representation form. Thus, Hegel did not only purport to derive a particular kind of representation from the idea of the, quote, universal, end quote. Hegel also derived from it a hereditary upper chamber. Further, as a form of mediation, Hegel confined representation to the sphere of the legislature, that organ of the state whose power is to, quote, determine and establish the universal, end quote. The specific object of legislation was the enactment of determinate and universal laws, quote, the ways and means of enforcing them, end quote, however, were generally a matter for the executive, which was not to be subject to election of any kind. In other words, representation was, first, to be based on trust rather than commission. Second, it was to be based on estates and a separate House of Lords. Third, it was to be limited to the sphere of legislation and excluded from the sphere of the executive. This, for Hegel, was the specific form which representation was to take in order to impose the, quote, general will, end quote, over the, quote, will of all, end quote. Hegel defined the executive as, quote, the power to subsume single cases and spheres of particularity under the universal, end quote. In this case, the mediation between civil society and the state was not through representation, but through the construction of a specific class whose interests were said to be divorced from those of civil society, and identified instead with the universal interests of the state as a whole. Thus, this was the class of civil servants, or the bureaucracy. By being paid salaries as state employees, the bureaucracy were to be relieved of having to supply their own personal needs through labor in civil society or through corruption. Bureaucrats were to be appointed on merit based on the passing of public examinations. Their positions were to be open to all citizens. Their offices were to be neither saleable nor transferable by gift or inheritance. Hegel, for instance, criticized the practice which still survived in England of purchasing commissions in the army. They were to have tenure so long as they performed their duties and were to be subject to hierarchical controls from above and pressures from below by the representatives of the estates to ensure against the abuse of their powers. Through the establishment of a rational bureaucracy, Hegel believed that he had found the solution to the problem which had plagued classical jurisprudence, the formation of a class of people whose interests were identified with those of society in general, and who were conscious of this identity. Quote, what the state really requires, end quote, Hegel wrote, quote, is that men shall forego the selfish and capricious satisfaction of their subjective ends, and by this very sacrifice acquire the right to find their satisfaction in, but only in, the dutiful discharge of their public function, end quote. Hegel believed that a rational bureaucracy met this requirement, especially as most civil servants were middle class. Quote, the class in which consciousness of right and the developed intelligence of the man of the people is found, end quote. Believing that, quote, the highest civil servants necessarily have a deeper and more comprehensive insight into the nature of the state's organization and requirements, end quote, than the people. Hegel reformulated the relationship between the executive and the legislature no longer as one of subordination of the one to the other, but as one of two complementary wings of a unified state. Hegel described as, quote, a most dangerous prejudice, end quote, the view of a division of powers which sets the assembly in opposition to the executive. Quote, to regard the will of the executive as bad, end quote, Hegel argued, quote, is a presupposition characteristic of the rabble, end quote. Montesquieu's general doctrine concerning the, quote, division of powers, end quote, made the, quote, fundamental error, end quote, of supposing that independent powers are merely a, quote, check, end quote, on one another. Such independence, Hegel concluded, quote, destroys the unity of the state, and unity is the chief of all desiderata, end quote. As regards the subordination of the executive to the judiciary, Hegel displayed his opposition by abolishing altogether their separation, the executive and the judiciary separation, and including the judiciary under the rubric of the executive. The bureaucracy was now elevated as the major partner among the organs of the state. The third element in Hegel's division of powers and the third form of mediation was the crown or monarch, quote, the power of subjectivity, as the will with the power of ultimate decision, end quote. It was a constitutional monarchy which Hegel had in mind, one on which substantive decisions were taken according to the principles laid down in the Constitution, but then given a formal ratification by the monarch in order to count as valid decisions of the state. Since this is all the monarch has to do, Hegel argues that it matters not what his or her personal attitudes are. All that does matter is the stability of the monarchy, because of its symbolic importance in representing in one person the will of the people. Under these circumstances, the most appropriate means of selection is primogeniture, which leaves the private character of the monarch to chance but ensures the stability of the throne. This works well because, quote, in a well-organized monarchy, the objective aspect belongs to the law alone, and the monarch's part is merely to set to the law the subjective, quote, I will, end quote, end quote. If the deputy was raised above the particular interests of civil society by means of representation, and the bureaucrat by means of hierarchy and the like, the monarch is thus elevated by virtue of his or her natural and not social being. Every society must have a leader, quote, there must always be individuals at the head. Everything is brought to completion by the single decisive act of a leader, end quote. These, then, were the mediations through which Hegel hoped to subordinate the real will of flesh and blood individuals to the rational will of the whole. The rule of law, the, quote, police, the constitution, monarchy, representation, and bureaucracy. Hegel's attempted synthesis between the private will of individuals in civil society and the rational will of the state turned out, however, to be an unhappy marriage. In effect, he idealized the state as the embodiment of reason and the bureaucracy as the embodiment of the state. In Hegel's succinct terminology, the mind which, quote, knows and wills itself, end quote, is the state mind. Hegel's formal identification of, quote, external authority, end quote, with, quote, immanent reason, end quote, was clearly revealed in his comments on crime and punishment. Crime appeared not merely as a violation of the positive laws of the state, but for this reason as a violation of one's own rational consciousness. Punishment appeared as a right established within the criminal himself. Crime appeared Crime appeared not merely as a violation of the positive laws of the state, but for this reason as a violation of one's own rational consciousness. Punishment appeared as a right established within the criminal himself. Punishment is regarded as containing the criminal's right, and hence, by being punished, is honored as a rational being. It seemed that punishment, rather than being an act of force by one person or set of persons against another, is the criminal's self-retribution. Hegel took the formal identity between the state and the people to its limit. On the one hand, establishing a Hegel took the formal identity between the state and the people to its limit. On the one hand, establishing an identity between the state and the people by locating the, quote, real will of the people, will of the individual in the state. On the other, establishing a chasm between the state and the people by abstracting the state from the real will of individuals in society and elevating the state as a special power alienated from the people. The fetishism of the state, which to varying degrees was present throughout classical jurisprudence, the idea that the external authority of the state is the rational will of the individual, finds in Hegel's idealism its ultimate expression. While his project, that of creating a synthesis between individual freedom and collective authority, represented a high point in the liberal tradition, his solution was both mystificatory and authoritarian. It was from this contradictory heritage that Marx took off.